Okay, so I'm first on the spot today. You're going to have to bear with me because my subject isn't the most interesting, but I will try and make it as interesting as I can. Basically, I'm going to be speaking to you all about compulsory winding up versus creditors and voluntary liquidations. Last year I spoke about dissolution and comparing it with winding up, so I'm going to do the same this year, compare and contrast. Okay, so in my opinion, there are 8 main headings in regards to this subject. Basically, they're in your booklets and on the screen as well. First one you've got is commencement, timing, investigations, the involvement of members, the costs involved, stays of execution, jurisdiction issues, and the liquidator. Okay, so firstly, commencement. How do you commence both procedures? In a CVL, the process begins at a meeting of directors, commonly known as the board meeting. At this meeting, the directors pass several resolutions, including one to call a meeting of the members of the company, where several other resolutions will be passed, include a resolution to wind up the company. This requires the agreement of the directors and the members of the company, and it is impossible to wind up the company without the agreement of both. However, in a compulsory winding up, this isn't the case, and the process starts with a winding up petition. There are several reasons why a winding up petition is served, and on the screen there are just a few. The creditor petitioning as a result of the expired statutory demand, which is over £750 at the moment. Creditor petitioning as a result of an outstanding judgment, a CCJ. I'm sure most of you have been aware of these and dealt with these in the past. The shareholder wanting to wind up the company and the directors won't call the general meeting. And finally, the director where the shareholders will not pass a resolution after the meeting has been called, an impasse. Most commonly though, as you're all aware, it's done by a creditor owed more than £750. It is looking to go up soon, we believe. It's been this limit since 1986, so it's due an upgrade sooner or later. Okay, so the other way you can do it, as I said before, there is obviously the directors and shareholders. They can both issue a winding up petition when there's a stalemate. On the screen now, you're going to see, obviously, again, why this can happen. If the director passes a resolution to call the meeting of the members, but the members refuse or are unable to pass a resolution to wind up the company, it requires 75% of the members to agree to wind up the company. Therefore, if you have 2, 50-50, you need both to agree. The second one is obviously the members want you to do it because they feel there's something wrong with it. The company is insolvent, needs winding up, needs to cease. And the directors, because they may have done something wrong, they won't call the meeting to wind up the company. Okay, secondly, we've got timing. Can be a very important factor when deciding whether or not to wind up the company voluntarily or do it through the courts. In a CVL, the procedure is relatively quick, and there is usually only 3 weeks from instructing us to calling the meeting. The period of 14 days is required by the shareholders to call the meeting. We can waive this if we have 90% of shareholders to agree. Again, it's a percentage issue. If you have 1 shareholder, fine. Husband and wife, usually fine. If there's 3 or 4, you can have a problem. The other benefit of a CVL is obviously this control. Everyone likes to control the situation if they can. Obviously, if you're going on holiday, the directors, or if there's a key date coming up, so you need to finish a key contract, finish the contract, then call a meeting. It's control again. We then contrast this with a compulsory winding up. It's commenced through the courts. Obviously, you have to wait for the courts to give you a time allocation to have the meeting, to have the hearing to wind up the company. It can be significantly longer, up to about 3 months, maybe more. It's not just as simple as waiting 3 months and the company's wound up. There are obviously other factors as well. You have obviously, as soon as the petition is served and advertised in the London Gazette, the bank account is frozen. The petition, obviously, once it's advertised in the London Gazette, you'll have someone at the bank, I believe, I'm sure someone can tell me if I'm wrong, you have someone who sits there, goes to the London Gazette to make sure the clients that you have at the bank aren't involved in the insolvency procedure. This is basically to ensure there's no recourse back to the banks if any money is withdrawn post-petition. They protect themselves. Also, any dispositions or the sale or disposal of assets can be challenged, and therefore no dispositions should be made between the time of petition and winding up. Ultimately, this includes stock, and with no sales and your bank account frozen, you may as well shut shop. There's also no control of timing the compulsory winding up for the company or the petitioner, and therefore this is another problem. Thirdly, we have the subject of investigations. In both procedures, the office holder has a duty to investigate and prepare a report on the director's conduct, which is obviously the CDDA, Company Directors Disqualification Act. Again, I think it's 2006, but don't quote me on that. 2 reports that we have to do, or any office holder has to do. You've got your good one, the D2, and obviously you've got your adverse on an unfit director, which is a D1. No one finds out which one has been reported on, but usually you have a good idea. In a CVL, the actual duty to actually investigate comes from the Statement of Insolvency Practice 2, SIP 2. It's like a guidance note for us as insolvency people to actually make sure that we do everything to the book. However, in a compulsory winding up, it's the official receiver who investigates the company and also the conduct of the directors. The main difference between these 2 procedures being that in a compulsory winding up, it is presumed there's something to investigate, and in a CVL, a director is actually in the best interests of the company, and therefore he's doing something good for the company. Most people, myself included, believe that in a compulsory winding up, you're more likely to be disqualified. Pulled apart by a very stern-looking lady in a grey room, and whilst this probably may be the case on some occasions, it's usually down to who makes investigations and obviously what you've done wrong. In a CVL, all I would say is we tend to approach the subject very early on, because obviously we don't want any nasty surprises. We want to make sure that both you and your clients are aware of what may go wrong and what we have to approach right at the very beginning. Right, next we have the members' involvement. Members, shareholders, both same thing, 2 different terms. Whilst we usually obviously discuss the directors call a meeting, we have the first meeting with the directors. As we mentioned before, you can't do anything without the agreement of the shareholders. So we need to discuss them. In a CVL, they are heavily involved in the process, and ultimately they're the ones who place the company into liquidation at the general meeting. They control the agenda, they attend the shareholders of the company at the meeting, and at this meeting they put forward their choice of liquidator. Which is quite originally referred to as the members liquidator. After this, if no other liquidator is appointed at the creditors meeting, then the members liquidator is approved by the creditors, and that is the liquidator of the company. When we compare this to, or contrast it to a compulsory winding up, it's very different. The members have no involvement whatsoever. They can only have involvement in the following 2 situations. If they defend the winding up petition, or as we said before, they are the petitioner. The basis, again, the directors refuse to call a meeting of members, or the members believe the directors are unfit. Obviously, if the directors are unfit and you believe they are, wind the company up through the courts, there is more investigations in compulsory winding up. Right, next we have one of the most important factors that everyone considers, directors and shareholders, when they consider whether to wind up their company through the courts, obviously voluntarily, and that is costs. The subject of costs can be a blocking point for any director or shareholder of an insolvent company, and often the company cannot afford to pay our fees to liquidate their company. In a compulsory winding up, the costs of the procedure are paid by the petitioner, and obviously, as the 2 fees are on the board, the deposit of £1,250 paid to court, and the fee again paid to court of £280. It is cheaper all round to do it through the courts than it is voluntary. These costs are often increased by the need to instruct a solicitor to prepare the necessary paperwork, and as I know there are a lot of solicitors in the room, I'm not even going to mention costs. There is no monetary cost to either directors or the shareholders in the compulsory winding up. However, in a voluntary liquidation, the costs are paid by the company, the directors or the shareholders, and needs to be paid up front on most occasions. I say most because obviously there's always factors. If there's assets, we can take our fees from the assets of the company. It's not always a blocking point. If there's a balance at bank, then the fees to liquidate can be paid by the company bank account. There's no problem in that. However, sometimes, usually, the directors will pay up front. Rough indication of our upfront fees will be from about £3,500 plus VAT, but there are factors that differentiate this. Okay, so next we have stays of execution. It's a very long subject, so I do apologise. basically what happens with execution process in both procedures. Ultimately, because of the quirky aspects of the law and the involvement of the courts, it's more of a comparison than a contrast. In a compulsory winding up, there's an automatic stay on executions, as per section 128 of the Insolvency Act. However, the court does have a discretion to allow it to continue, which is where we're going to see the comparison. It will usually allow the execution to continue if it is a validly owed debt. It will not affect the preferential creditors by allowing it to do so. However, in a CVL, section 128 does not apply, and therefore executions are not automatically void. The liquidator can, however, apply to court under, and I apologise for the section numbers, section 112 of the Insolvency Act, to basically ask the court to give directions as to continuing. Almost certainly, the court will exercise the right to allow it to be automatically stayed. We're back to comparing again. Another section number which applies to both procedures is section 183 of the Insolvency Act, which is the effect of execution or attachment. This applies where the creditor has started execution, the company is subsequently wound up. If the execution is not complete, i.e. the handing over of the sale or proceeds to the instructor, and the creditor has received notice that a general meeting is being called, they must hold those monies and deliver them up to the proposed liquidator. In essence, that is what is supposed to happen. At the moment, there is a problem with HM Revenue and Customs where they believe they don't have to do so. So there's something going to be moving on at the moment. Basically, it's a minefield. I'm more than happy to speak to anyone after on stage of execution another time. Okay, nearly there. I'm trying to make it interesting, so I do apologise. So I thought I'd reflect on a few photos which make me happy. I am an Arsenal fan, so I apologise to anyone else in the room. I'll keep it quick. Okay, back to the fun stuff. Okay, we have jurisdiction issues. Whilst it's not ultimately a cause for concern for many directors we come across, it is important to note there are differences between the two procedures when looking at DC assets. It's a massive subject, I don't want to get too wrapped up into it. I'm happy to discuss it after. I'll just approach the subject very quickly. In a CVL, you will require court confirmation in order to transfer the proceedings in England and Wales to another European state. That basically means you have to apply to court using a solicitor, paying the fees via Form 7.20. It makes it longer, but you have to apply to get court confirmation. It's not automatically over there. Basically, compared to a compulsory winding up, it's included in the winding up petition. So basically you say whether or not EC regulations will apply. Do you have assets in a European state? If so, put it on the petition. Easy. Basically then you just take it over to that EC member state, you give notice to the liquidator in that state, you have the confirmation automatically. So therefore if you have assets abroad and you will need to be dealing with them, property, assets taken out of the country, compulsory wind up. It will be a lot easier for you. Finally, we have the subject of the liquidator. This is also a very big factor in choosing whether to compulsory wind up or liquidate voluntarily. You have to pick the right person. In a CVL, the directors and shareholders will meet an insolvency practitioner, an initial meeting to discuss the affairs of their company. At this point, there may not be any decision made in respect of the company, however, you are starting the procedure there and then. In the vast majority of cases, however, it will be that insolvency practitioner that will then take you through the process, call a meeting of creditors, prepare the documents to wind up the company. It's the same sort of thing. At the meeting of members, as we said earlier, the members will vote on their choice of liquidator. It may be us. Then the creditors may choose then to bring someone else in, another insolvency practitioner. It then either means you have the job or you have to share the job, and there's a division of duties. The choice is then proposed to the meeting of creditors. It's up to them to appoint, as I just said. It's literally, they can either appoint you or choose someone else, a friendly IP. However, in a compulsory winding up, the official receiver is always appointed liquidator following the making of the winding up order. If there's assets or matters to be investigated, they will then appoint someone like us, either by a meeting of creditors, or they will choose to do it by the IP rota. The IP rota is basically a big will. All the IPs in the area are on that will. And basically the next person round takes the job. If you don't want the job for any reason, a conflict, it goes to the next person and so on. However, you can't turn down many jobs because there's not enough money. You have to take the job every now and again. Therefore, if you have a specific choice of liquidator. Then you should liquidate the company voluntarily, as there is no guarantee you'll be happy with the liquidator that you are given. Oh, sorry. Whilst there are several factors which come into play when considering whether or not to liquidate a company voluntarily or allow a creditor to wind it up, the main reason we are looking at is control. Everybody likes to control the situation if you can. If you build up a business you've worked with or worked on for 10, 20, 30 years, it could even be a couple of years. It's your business. You want to control when you push the button. When instructing a liquidator to liquidate it voluntarily, you need someone you can trust and ultimately you get on with. People do not do business with a company, they do business with people. They need to feel that you're understood and the guarantee that we will administer each case with a personal touch. I hope you enjoyed my speech. Any questions, speak to me after. I'm more than happy to speak to anyone on it. I'm now going to pass you on to Debbie, who will be going through a case study on a CVA that we were involved in, myself included, and how a validation order can be used. Thank you very much.